This reading is going to come from the Chattel Mortgage Act, being Chapter 200 of the Revised Statutes of Saskatchewan, 1920, assented to November 10th, 1920. Table of content. I'm not going to read that. Chapter 200. An act respecting mortgages and sales of personal property. Short title. An act may be cited as the Chattel Mortgage Act. Interpretation. Creditors. 2. In the application of this act, the word creditors, where it occurs, shall extend to creditors of the mortgagor or bargainer suing on behalf of themselves and other creditors, as well as to creditors having executions against the goods and chattels of the mortgagor or bargainer in the hands of the sheriff. Restriction districts. 3. For the purpose of the restriction of mortgages and other transfers of personal property in Saskatchewan, each judicial district shall be a registration district. Registration clerk. 4. The lieutenant governor in council may appoint a registration clerk and a deputy registration clerk for each registration district, who shall severally hold office during pleasure. 5. Deputy to act in the event of a vacancy in the office of the registration clerk or of his illness or absence. The deputy registration clerk shall perform all the duties required of the registration clerk by this or any other act. Location of offices and office hours. 6.1. The office of the registration clerk shall be at the judicial century of each district and shall be kept open between the hours of 10 in the forenoon and 4 in the afternoon on all days, with the following exceptions. A. On Sunday and holidays, the office shall be closed. And B. On Saturdays and during the period of vacation prescribed by the King's Bench Act and the rules of court of office, shall be closed at 1 o'clock in the afternoon. 2. Registration shall be made during office hours only. No clerk to withdraw documents. 7. No registration clerk, deputy registration clerk, or clerk in the office of the registration clerk shall draw or prepare any document or conveyance which may be filed or registered in such office under the provisions of this or any other act. Registration where new district formed. Effect of establishing new districts. 8.1. In the event of the establishment of a new judicial district, all chattel mortgages relating to property within such districts shall continue to be as valid and effectual in all respects as they would have been if the new district had not been established, and no chattel mortgage in force and filed at the date of the establishment of such new district shall lose its priority by reason of its not being filed in the office of the registration clerk of such new district prior to its renewal. 2. In the event of a renewal of any such chattel mortgages after the establishment of a new district, the renewal statement shall be filed in the office of the registration clerk of such new district together with the certified copy of the chattel mortgage to which such renewal statement relates, and of any renewals thereof under the hand of the registration clerk in whose office the same were filed. Mortgages and sales of chattels, form and registration. Mortgages unaccompanied by delivery and change of possession of goods. 9.1. Every mortgage or conveyance intended to operate as a mortgage of goods and chattels, which is not accompanied by an immediate delivery and an actual and continued change of possession of the thing mortgaged, shall within 30 days from the execution thereof be registered as hereinafter, provided together with an affidavit of a witness thereto of the due execution thereof, given the date of the execution. B. An affidavit of the mortgagee or one of the several mortgagees, or the agent of the mortgagee or mortgagees, if such agent is aware of all of the circumstances connected therewith and is properly authorized by power in writing to take such mortgage, and a copy of such authority is attached thereto, except as provided under Section 27, stating that the mortgagor within named is justly and truly indebted to the mortgagee in the sum mentioned in the mortgage. Or 2, that it was executed in good faith and for the express purpose of securing the payment of money justly due or accruing due, and not for the purpose of protecting the goods and chattels mentioned therein against the creditors of the mortgagor, or of preventing the creditors of such mortgagor from obtaining payment in any claim against him. 2. Every such mortgage or conveyance shall operate and take effect upon, from, and after the time of the following thereof: mortgage gives to secure bonds and in debentures. 10.1. In the case of a mortgage or conveyance of goods and chattels of any incorporated company made to a bondholder or bondholders, or to a trustee or trustees for the purpose of securing the bonds or in debentures of such company, instead of the affidavit of bona fides required by Section 9, it shall be sufficient if an affidavit is filed made by the mortgagee or one of the mortgagees to the effect that the said mortgage or conveyance was executed in good faith and for the express purpose of securing the payment of the bonds or debentures referred to therein, and not for the purpose of protecting the goods and chattels mentioned therein against the creditors of the mortgagors, or of preventing the creditors of such mortgagors from obtaining payment of any claim against them. 2. Any such mortgage may be renewed in the manner and with the effect provided by Section 22 and subsequent sections of this Act upon the filing of a statement by the mortgagee and one of the mortgagees exhibiting the interests of the mortgagee or mortgagees in the property claimed by virtue of the said mortgage, and showing the amount of the bond or debenture debt which the same was made to secure, in all payments on account thereof, which to the best of the information and belief of the person making such statement have been made, or of which he is aware, together with an affidavit of the person making such statement, that the statement is true to the best of his knowledge, information, and belief, and that the mortgage has not been kept on foot for any fraudulent purpose, and such statement shall be filed instead of the statement required by the same section 22. I said section 22. 3. If any mortgage as foresaid is made to an incorporated company, the several affidavits and statements herein mentioned may be made by the president, vice president, manager, or assistant manager of such incorporated company, or any other officer of the company authorized for such purpose, in which latter case such authority or a copy thereof shall be filed with the affidavits. 4. Where such mortgage or conveyance is made as a security for bonds or debentures, and the bylaw authorizing the issue of the bonds or debentures as a security for which the mortgage or conveyance was made, or a copy thereof certified under the hand of the president or vice president and the secretary of the company, and verified by an affidavit of the secretary thereto attached and endorsed thereon, and having the corporate seal attached thereto, is registered with the mortgage or conveyance, it shall not be necessary to renew the said mortgage or conveyance, but the same shall in such case continue to be as valid as if the same had been duly renewed, as in this act provided. Mortgage form. Number 11. Except as provided in section 12, a mortgage or conveyance intended to operate as a mortgage of goods or chattels may be made in accordance with Form A. And in the back they got forms. Mortgage to secure future advances or to indemnify endorsers. 12.1. The following mortgages, if executed in good faith and setting forth fully by recital and otherwise the terms and nature and effect of the agreement and the amount of liability intended to be created, and if registered as hereinafter provided within 30 days from the execution thereof, shall be a valid and binding as mortgages given under section 9. 8. A mortgage of goods and chattels for securing the mortgagee repayment of advances given in pursuance of an agreement in writing for future advances for the purpose of enabling the borrower to enter into and carry on business with such advances. B. A mortgage of goods and chattels for securing the mortgagee against the endorsement of any bills of exchange or promissory notes or other liability by him incurred for the mortgagor, not extending for a longer period than 2 years from the date of the mortgage. 2. Such mortgages shall be accompanied by an affidavit of a witness thereto of the due execution thereof, and B, an affidavit of the mortgagee and one of the several mortgagees or of an agent. in case the agreement has been entered into and the mortgage takes by an agent duly authorized in writing to make such agreement and take such mortgage, and in case a copy of such authority is attached thereto, and the agent is aware of the circumstances connected therewith, stating, I, that the mortgage truly sets forth the agreement entered into between the parties thereto, and truly states the extent of the liability intended to be created by such agreement and covered by such mortgage, and or two, that such mortgage is executed in good faith and for the express purpose of securing the mortgagee repayment of his advances, or against the payment of the amount of his liability for the mortgagor, as the case may be, and not for the purpose of securing the goods and chattels mentioned therein against the creditors of the mortgagor, nor to prevent such creditors from recovering any claims which they may have against such mortgagor. What I keep seeing is, they keep saying the mortgagee repayment in his advance, a repayment. Sales of goods not attended by delivery and change of possession. 13.1. Every sale, assignment, and transfer of goods and chattels not accompanied by an immediate delivery and followed by an actual and continued change of possession of the goods and chattels sold, and every assignment by any retail merchant or trader of book debts, accounts, and debts to the occurred shall be in writing, and such writing shall be a conveyance under the provisions of this act, and shall be accompanied with an affidavit of a witness thereto of the due execution thereof, and an affidavit of the bargainee, or one of the several bargainees, or of the agent of the bargainee, or the bargainees duly authorized in writing to take such conveyance, a copy of which authority shall be attached to the conveyance, that the sale or the assignment by any retail merchant or trader of books, debts, accounts, or debts to be incurred is bona fide and for good consideration as set forth in the said conveyance, and not for the purpose of holding or enabling the bargainee to hold the goods, book debts, accounts, or debts to be incurred mentioned therein against the creditors of the bargainer. And such conveyance and affidavit shall be registered as hereinafter provided within 30 days from the execution thereof. Otherwise, the sale shall be absolutely void, as against the creditors of the bargainer, and as against subsequent purchasers or mortgagees in good faith. 2. Such affidavit shall further state that the goods or chattels covered by such conveyance are not sold in bulk within the means of the Bulk Sales Act, or in case of a sale in bulk, such conveyance shall be further accompanied by an affidavit of the bargainer setting forth a complete list of his creditors, or by the written waiver referred to in Clause 1 of Section 6 of the said Act. Affidavit and renewal unnecessary in certain cases where a mortgage or conveyance intended to operate as a mortgage of goods and chattels, or any sale, assignment, or transfer of goods and chattels, book debts, accounts, or debts to be incurred is made in favor of his majesty. It shall not be necessary for the mortgagee or the borrower or his agent to make the affidavit of bona fides required by this act and the provisions of this act with respect to renewal shall not apply to such mortgages and conveyances. Registration only affects district where made. 15. A mortgage or conveyance or bill of sale registered under this act shall only have effect in the registration district wherein such registration has been made. Omission to register or false statement of consideration. In case such mortgage or conveyance and affidavits are not registered as hereinbefore provided, or in case the consideration for which the same is made is not truly expressed within the mortgage or conveyance, shall be absolutely null and void as against creditors or the mortgagor, and against subsequent purchasers or mortgagees in good faith for valuable consideration whose conveyance or mortgages have been duly registered or are valid without registration. I'm going to read that one again. I think that's very important. In case such mortgage or conveyance and affidavits are not registered as hereinbefore provided, so if you don't register it, or in case the consideration for which the same is made is not truly expressed therein, the mortgage or conveyance shall be absolutely null and void against the creditors or the mortgagors, and against subsequent purchasers or mortgagees in good faith for valuable consideration who conveys or mortgages have been duly registered or are valid without registration. Oh, my head hurt. Description of property. 17. All the instruments mentioned in this act, whether for the mortgage, sale, assignment, or transfer of goods and chattels, book debts, accounts, or debts to be incurred, shall set forth the names, surnames, additions, and post office addresses of all the parties thereto, and shall contain such sufficient and full description of such goods and chattels that the same may be readily and easily known and distinguished. Registration in district where property situate. 18. The property registration officer for instructions being mortgages and transfer of personal property shall be the clerk of the registration district in which the property described in the mortgage or transfer is at the time of the execution of the instrument, or in case of a sale, assignment, or transfer of book debts or accounts, the clerk of the registration district in which the vendor, assigner, or transferor carries on business, which registration clerk shall file all such instruments presented to them respectively for that purpose, and shall endorse thereon the time of receiving the same in their respective offices, and the same shall be kept there for the inspection of the public, subject to the payment of the proper fees. Clerk to register instrument. Every such clerk shall number each instrument or copy filed in his office, and shall enter in alphabetical order in the book to be provided by him the name of the mortgagor in each such instrument, with the number endorsed thereon opposite to each name. Conveyance of growing or future crops. Securities on crops and supplies. 21. No mortgage, bill of sale, lien, charge, encumbrance, conveyance, transfer, or assignment made, executed, or created, and which is intended to operate and have effect as a security shall, insofar as the same assumes to bind, comprise, apply to, or affect any growing crop or crop to be grown in future, in whole or in part, be valid, except the same be made, executed, or created as a security for the purchase price and interest thereon of seed, grain, or for meat, groceries, flour, clothing, and binder twine. 2. Every mortgage or encumbrance upon growing crops or crops to be grown, made or created to secure the purchase price of seed grain shall be held to be within the provisions of this act, and the affidavit of bona fides among the other necessary allegations shall contain a statement that the same is taken to secure the purchase price of seed grain. 3. No mortgage or encumbrance to secure the price of seed grain shall be given upon any crop which is not sown within 1 year of the date of the execution of the said mortgage or encumbrance. 4. Every registration clerk shall be entitled to receive the same fees for his services as provided for under Section 39. 5. No such seed grain mortgage so taken and filed shall be affected by or subject to any chattel mortgage or bill of sale previously given by the mortgagor, or by any writ of execution against the mortgagor in the hands of the sheriff at the time of the registration of such seed grain mortgage. But such seed grain mortgage shall be a first and preferential security for the sum therein mentioned, the date of the purchase of seed grain, the number of bushels purchased, and the price thereof per bushel shall be stated in the mortgage, as well as in the affidavit of bona fides. 6. Mortgages or encumbrances upon growing crops or crops to be grown may be given to the extent of $250 in the aggregate of all such mortgages and encumbrances upon the crops, of a quarter session of $350 in such aggregate upon the crops of a half session, or of any greater quality of land. The security for the purchase price and interest thereon of meat, groceries, flour, clothing, and binder twine. This son gonna just keep moving around. Binder twine. All right, 7. Every mortgage or encumbrance given under Section 6 shall be held to be within the provisions of this act, and the affidavit of bona fide shall, among the other necessary allegations, contain a statement that the same is taken to secure the purchase price of food or supplies, specifying the nature of such food or supplies. 8. Nothing in subsections 6 and 7 contained shall derogate from the priority above conferred upon seed grain mortgages, or from the priority given to seed grain advances under any act respecting advances to purchase seed grain, but subject to such priorities, the mortgage or encumbrance taken under subsection 6 shall not be affected by any encumbrance whenever created, or by any writ of execution against the mortgagor in the hands of the sheriff at the time of the registration, but such mortgage or encumbrance shall create a preferential lien next in priority after seed grain mortgages or seed grain advances as above mentioned. 9. No mortgage or encumbrance taken under subsection 6 shall be valid if any part of the indebtedness thereby secured was incurred prior to the first date of April 1916. Whenever we come back, we're going to get to that. Procedure under mortgage on default.